What is sexual harassment? Sexual harassment is a very serious issue that can occur whether you are in the workplace, classroom, or even when you are out with friends. Since caregivers and healthcare professionals are in constant contact with patients, sexual harassment is a grave offense that is taken extremely seriously. So what exactly is sexual harassment? According to the U.S. Department of State, sexual harassment is a form of sex discrimination. Sexual harassment broadly describes unwelcome and non-consensual sexual acts that can take many forms. Sexual harassment is not limited to unwelcome comments or advances. It can also include insulting and sexist remarks or promises of advancement in exchange for sexual favors. Types of sexual harassment. Sexual harassment may be physical, verbal, or nonverbal. It can occur in sexually coercive situations or in hostile work environments. Physical sexual harassment is described as unwelcome or non-consensual sexual physical contact. This includes acts including but not limited to unwanted hugging, kissing, patting, pinching, or stroking. As for nonverbal sexual harassment, actions including but not limited to whistling, leering, or the display of sexually explicit materials represents sexual harassment. In the workplace, sexual coercion, also known as quid pro quo, is sexual harassment. Quid pro quo occurs when employment decisions, such as hiring, firing, or promotions, are contingent on the employee performing sexual favors. For example, if a supervisor threatens to fire an employee who does not submit to sexual advances, this is considered quid pro quo. When a hostile work environment is created due to offensive, intimidating, non-consensual, or unwelcome conduct, this could unreasonably interfere with an employee's work performance. However, a hostile work environment is not necessarily created by unwanted sexual conduct. It can also include offensive sexual comments or jokes, discussion about sex and the display of sexually oriented material in the workplace. Essentially, a hostile work environment consists of various unwanted and non-consensual actions that are made about you, your body, your social preferences, or your personal life. Any unwanted conduct within a hostile work environment is illegal. Moving past the definition of sexual harassment, victims of sexual harassment may feel embarrassed or too afraid to come forward and report the incident. It is important for victims to understand that there are state and federal policies that protect individuals and employees subjected to sexual harassment. As an employee, you have the right to be protected against sexual harassment. In addition, you cannot be retaliated against for filing a complaint against the harasser. After submitting a complaint or telling your supervisor about the incident, you cannot be fired, demoted, suspended, or have your hours cut due to this incident. Federal and state laws regarding sexual harassment. The Department of State is committed to providing a workplace that is free from sexual harassment. According to the Department of State, sexual harassment is against the law and will not be tolerated in the workplace. When the department determines that an allegation of sexual harassment is credible, they will take appropriate measures to end any behavior that is fueling a hostile environment in the workplace. Even if an individual does not wish to file a formal complaint, the department is committed to take action if sexual harassment is evident in the workplace. Remedies for victims of sexual harassment. The Office of Civil Rights is the main contact point for questions or concerns about sexual harassment. They are responsible for investigating or overseeing investigations of alleged sexual harassment cases. The Office of Civil Rights is committed to ensuring that all investigations related to sexual harassment are conducted in a prompt, thorough, and impartial manner. During an investigation, they will seek to protect the identities of the victim and the harasser, except under certain circumstances. In the case where supervisors and department officials are informed or reasonably suspect incidents of possible sexual harassment, they must immediately report such incidents to the Office of Civil Rights. Any failure to report such incidents will be considered a violation and may result in disciplinary action. After the completion of a full investigation, supervisors should take effective measures to ensure no further apparent or alleged harassment occurs. As previously mentioned, it is a violation of federal law to retaliate against someone who has formally reported sexual harassment. Employee rights and responsibilities under state policy. Let's say Anna, your coworker, believes she has been a target of sexual harassment in the workplace. Although policies against sexual harassment encourage victims to inform the harasser of their inappropriate behavior orally or in writing, she is uncomfortable communicating directly to her harasser. Although Anna believes she only has one option, she has multiple avenues to address this serious issue. As an employee, Anna should be encouraged to report the unwelcome conduct to a department official, such as her supervisor, the management office, or the Bureau's executive director, as soon as possible. Another option is for Anna to file a formal complaint to the Equal Employment Opportunity Commission, EEOC. The EEOC will pursue the case and will protect Anna's rights under state policy. Bystander interventions and resources are available at. It must be clear that not all cases of sexual harassment are similar to Anna's situation. In any case, there are other ways to pursue a resolution. First, mediation may assist in facilitating communication between both parties during the dispute. This route provides an informal way to resolve work-related problems through a trained mediator. An employee can contact the Office of Civil Rights to ask for assistance from a mediator. If an employee chooses mediation, management is obligated to have a representation during the mediation process. If a resolution is not reached, the parties may continue to pursue resolution through other necessary means. According to the Equal Employment Opportunity (EEO) process, all employees working in the United States or are U.S. citizens working for the department overseas can file an EEO complaint with the department. Within 45 days of the incident, an employee who wishes to file a complaint under EEO procedures must consult an EEO counselor. In this scenario, it is not necessary for an employee to complain to his or her supervisor before approaching an EEO counselor. A procedure for the investigation of complaints is timely, confidential, and ensures due process for all parties. Sexual harassment laws for New York employees. Under state laws, employers cannot require employees to submit sexual harassment claims to arbitration. As of April 12, 2018, non-employees are now covered under the state's non-discrimination law. Coverage under the New York State Human Rights Law is now extended to non-employees, such as contractors, subcontractors, vendors, consultants, and other persons who provide services under a contract. If the employer knew or should have known about the harassment and failed to take immediate and appropriate corrective action, Employers will be liable for sexual harassment involving non-employees. As of July 2018, non-disclosure provisions will be prohibited from settlement agreements for harassment claims without the expressed consent of the complaining party. To demonstrate that the non-disclosure provision is the complaining party's preference, he or she must be given 21 days to consider whether to accept the non-disclosure language. Then, if anything changes, the complaining party has 7 days to revoke their acceptance. The employee cannot waive the 21 and 7-day periods. New York laws. Following state policies in New York, the statute of limitations period was extended from 1 year to 3 years for gender-based harassment claims. Additionally, training was made mandatory to provide employees with information on their rights. Training provided an explanation on how to bring complaints both internally and externally with the help of applicable federal, state, and city administrative agencies. To further assist victims, forums were made available for adjudicating complaints administratively and judicially with access to contact information. Again, it is important to understand the prohibition of retaliation as an important policy that protects victims of sexual harassment that submit formal complaints. Under New York City laws, all employees can submit complaints to the New York State Division of Human Rights, Federal Equal Employment Opportunity Commission, EEOC, and a court that has appropriate jurisdiction. In addition, all employers are covered by anti-harassment laws. Regardless of size, the existing city law prohibits gender-based harassment to all employers. For internal formal complaints regarding sexual harassment, the victim should report the sexual harassment to their employer. After, the victim should follow any company procedures for complaints or grievances. In your file, include items such as direct quotes, patterns of harassment, and names of witnesses. If you are unsure about the formal complaint process, the process is available through the New York State Division of Human Rights and the EEOC. Remember that all employees in New York can make complaints to each agency.